Hello, I'm Ashley Strauss-Martin, General Counsel for the New Mexico Association of Realtors, and I'm here today to talk to you about our new objection, response, and resolution process and the forms that go along with that process. These forms and that process will replace what we consider the ORW process and the ORW form that's currently in our library. Before we get started with the changes, I want to talk for a moment about the problem with the current form. So the current form is a standalone form. It doesn't say the word amendment or the word addendum on the form anywhere. The current form doesn't allow for the negotiation of a dollar amount for a price modification or a seller concession. There is a box on there for the seller to say that they're willing to offer one of those as a resolution to buyer's objections. However, there's no place to negotiate a dollar amount, so the buyer can't agree to any of those things because there's no place to negotiate dollars on that form. And instead, the form pushes the parties off onto our price modification seller concession form. So that is an amendment to the contract, and that form always has to go to the lender. However, what's happening with the current ORW, because the word amendment is not on it, parties are being led to believe that there can be a lot of negotiation, a lot of changing of the purchase agreement without those changes having to go to the lender. And sometimes, even though we do not provide a place for dollars to be negotiated on that form, people are negotiating dollar reductions in the price or seller concessions on that form. Further, they're negotiating a number of repairs on that form, sometimes very extensive repairs. Now, you have to remember that in our purchase agreement, the seller has no obligation to reduce the price or to give a seller concession or to do any repairs to the property in order for the buyer to have to buy the property. The purchase agreement does not require the seller to do any of those things. So if the seller is agreeing to reduce the price or give a seller concession or do any kind of repairs to the property, that is an amendment to the purchase agreement. And amendments must go to the lender. And that's not happening because too much is being negotiated on this form that doesn't make its way to the lender. Now, what's rather frustrating to me as counsel for the association and the person kind of charged with educating the brokers and trying to keep them out of trouble, so to speak, is the fact that sometimes it is the quote-unquote lender sitting on the other side of the table who is telling the broker, is telling the buyer, I don't want to see that form. I don't want to see that form that does whatever it does. And why would the quote-unquote lender say that? Well, that person that you're dealing with on the other side of the table is not the person who has to make the hard decisions about whether or not to make that loan or not make that loan. Those are decisions that are made by an underwriter. And an underwriter wants all of the information that they can get in order to decide whether or not they want to make a loan or not. So anytime that somebody is discouraged from giving the underwriter information that will help them make that decision, it's problematic. And it's problematic because of how we define mortgage fraud. As you see here on the screen, mortgage fraud is a subcategory of financial institutions fraud. It's a crime characterized by some type of material misstatement, misrepresentation, or, and this is the key point, omission in relation to a mortgage loan, which is then relied upon by the lender. So omission of information, holding back, keeping back information from an underwriter that would help the underwriter make a decision as to whether or not they want to make that loan or not. So a lie that influences a bank's decision about whether, for example, to approve a loan, accept a reduced payoff amount, or agree to certain repayment terms is mortgage fraud. And so anytime we are changing up the purchase agreement, whether we're doing a price modification or we're doing a seller concession, or the seller is now agreeing to do a number of repairs to the property in order for the buyer to be required to buy, that is an amendment to the contract, and that has to go to the lender every single time. So in kind of trying to figure out how we wanted to approach this, we thought about that whole process as a negotiation between the parties. And just because the buyer asks for things doesn't necessarily mean that the seller is going to agree to those things. And so this is the process that we're going to be using now and the solution to this problem. So what is this new process and what are these new forms? So typically under our current forms, the ORW, you have one form that the buyer completes and sends it over, and on that same form, the seller signs something, which if they agree to all of those buyer objections, that becomes an agreement between the parties as to how the buyer's objections are going to be cured. If they don't agree to everything, then they come back with their own suggested response, and the buyer then has the option of accepting that response. And if they sign the form, then they have accepted that response. So we're creating an agreement, we're creating an amendment to the purchase agreement with the ORW form. The new process is not going to work that way. The way the new process works is that there's a notice of objection, and that is signed only by the buyer, not by the seller. Even if the seller agrees to everything on that form, the seller doesn't sign the notice of objection. The notice of objection is drafted by the buyer, it goes over to the seller, and then the seller will create a separate document called a response to the notice of objection. And that response is only signed by the seller. Now, if everybody is in agreement at that point as to how to resolve the buyer's objections, the buyer objected, the seller said they'll do everything, then the parties will put together a third form, which is called a resolution addendum. In the event that the buyer doesn't like what the seller responded, the response that the seller gave, then the buyer will create a separate standalone response to notice of objections, and they will go back to the seller with what they would like to see in response to what the seller had told them. This is the process where the parties go back and forth on these separate forms. The notice of objection only signed by the buyer, the response initially only signed by the seller, then the response again only signed by the buyer. If there's another response by the seller, only signed by the seller. The documents preceding the resolution addendum are only going to be signed by one party or the other, never by both parties. It's not until the parties have reached resolution that they're going to sign the resolution addendum. And that resolution addendum is signed by both parties as an addendum to the purchase agreement or an amendment. It doesn't matter what you want to refer to it as, addendum or amendment. And that final resolution addendum must go to the lender if the buyer is getting a loan. Let's talk about the notice of objection first, because that's step one in the process. And the new form number for that is 5141. And I want you to think of this as the buyer's wish list. So this is, the buyer's gone through their inspections, reviewed documents, done their survey, and they have objections, and this is everything that they would like to see done. Now, I do want to point out, and this is important, that there could be multiple notice of objections. So you could have a buyer notice of objection for documents or a document, and a buyer notice of objection for inspections, and a buyer notice of objection from a survey. So you could have multiple buyer notice of objections, but based on that subject matter, again, whether it be inspections or documents or survey or what have you, this is what the buyer would like to see done in response to what they learned about the property. Before we get into the meat of the form, I want to point out this box at the top. It's got two very important points to it, and we want to bring the buyer and seller's attention to this. First of all, this is not an agreement. This notice is not an agreement. It's a form that is used in negotiating buyer's objections. The form does not create an agreement between the parties as to how to resolve the buyer's objections and cannot be used for that purpose. And you'll see when we get to the second page that only the buyer signs this form. Only the buyer signs the notice of objections. And if the seller doesn't sign it, then there's no agreement to do anything. It's, again, just the buyer's wish list. If the parties come to an agreement regarding how to resolve the buyer's objections, the parties shall execute a resolution addendum to the purchase agreement. So that's a couple more steps down the road, because there's got to be a response, and if everybody can agree, then the parties are going to enter into a resolution addendum to the purchase agreement, and that is an amendment to the purchase agreement, and that must go to the lender. And because of that, we have another bullet here that says consult with lender. A resolution addendum, or other items agreed to by the parties after the purchase agreement is fully executed, may alter the terms of the purchase agreement and require disclosure by buyer to buyer's lender. So buyer is encouraged to consult buyer's lender prior to entering into a resolution addendum, as the resolution addendum may A, have a detrimental impact on the buyer's ability to get the loan, B, cause delays in the lender's processing and funding of the loan by the closing date, and C, require further inspections and or repairs. So we're telling the buyer and the seller at this stage, along with the next stage, which is the response stage, and the final stage, which is the resolution addendum, we're telling them at all stages that before you enter into that final document, that resolution addendum, the buyer should be consulting with their lender, because what the parties have agreed to could have an impact on the buyer's loan. And so they should be talking to the lender about that before entering into that final document. Now, as you get into the meat of this form, paragraph 1 is what you're used to seeing in our purchase agreement regarding the buyer's right to do inspections and make objections. And A is what we already have in our purchase agreement if the buyer objects to an item on a document, and we have used and added the word video here. In the event that there is a video, a scope, for example, of the sewer system or something like that, that the buyer is objecting to, then if it's a document video or survey or ILR, then the buyer is going to produce with his objections a copy of the entire document, video, or survey on which the buyer's objections are based. And if the objection is to an item on an inspection report, then the buyer shall produce with the objections only the sections of the report on which the buyer objections are based. And either that or they're going to incorporate those sections into paragraph 2 below. And then we have added some additional language in this. As you know, the way that the purchase agreement currently works is because only those sections are being produced and not the entire report, the seller does have the option of getting the entire report upon request from the buyer. But the buyer has agreed in the purchase agreement that they will not send the entire inspection report unless requested by the seller in writing. And when we say, the buyer's not going to send it, we also mean that the buyer's broker isn't going to send it, because that's what the parties have agreed to in this purchase agreement. And the language we've now added to that section, which you will also see in the purchase agreement and in the purchase agreement video that is accompanying this video, is that upon seller's written request for the report, the buyer shall provide the report within 3 days of the seller's request. And we define days, and that's capitalized because we define days as calendar days, except for if the deadline for performance falls on a weekend or legal holiday, then it rolls over to the next business day. And the buyer shall provide the inspection report to the seller without any payment or other compensation. So the buyer is not entitled to being reimbursed for the report before they have to share that report with the seller if the seller has requested a copy of that report in writing. And then C is already in our purchase agreement. Once the buyer makes objections, buyer may not withdraw their objections for the purpose of terminating the agreement until the seller has had an opportunity to respond. And then if the seller doesn't give the buyer everything that they asked for in this notice of objections, then the buyer does have the option at that point to terminate the contract. The second paragraph talks about the actual objections. So what are we objecting to? Inspections, documents, buyer observations, you just check boxes there. And then you start into the buyer objects and gives notice to seller that the following items are unsatisfactory and requests the following cures. And I know that's not a lot of space on page 1, but as you move into page 2, you have a little more space, and we'll see that in just a moment. At the top of page 2 of the notice of objection, there is some additional white space, but I can already hear it. Not enough white space. So we have added this checkbox that says, if checked, additional space is required and Exhibit A is attached. So Exhibit A says, Exhibit A on the top of the first page, and it's 2 pages of just blank white space. You can write lots and lots of objections. So grab 2200 and check this box and include it as Exhibit A. Below that, there is a box that says attention buyer seller, and it's telling the parties what happens if no resolution is reached by the resolution deadline. And again, this is important because we are changing the way that works. Currently in our purchase agreement, if there's no resolution by the resolution deadline, then the contract will automatically terminate. But now we say, if there's no resolution by the resolution deadline, then the buyer shall have 2 days from the resolution deadline to provide written notification to seller that buyer is withdrawing all objections to which they have not come to resolution. So all unresolved objections. And we reference Form 5144, which is our buyer's withdrawal of objections, our general buyer withdrawal of objections. And if the buyer does withdraw all unresolved objections, then they will proceed with the contract. And in the event that they do not, then after that 2 days has run, the contract will terminate and earnest money will be refunded to the buyer. And it says, notwithstanding the foregoing, the buyer's withdrawal of all unresolved objections prior to the resolution deadline within 2 days following the resolution deadline constitutes resolution. Because if they withdraw their objections, then there's nothing to resolve because all unresolved objections have been pulled off the table. So a whole new way we're approaching that. This language will be in the purchase agreement as well, but it's important to know that it doesn't automatically terminate because there's no resolution by the resolution deadline. 2 days, within 2 days of the resolution deadline, the buyer can submit a withdrawal of all unresolved objections and keep the contract alive. And there's no objections to resolved at that point. Note that only the buyer signs this notice of objection. Again, it's not an agreement between the buyer and the seller because only the buyer is signing it. So it does not have to go to the lender. It's just the buyer's wish list, as I said before. And then below that, it gives the sellers the options. And option A is if the seller agrees to cure all of buyer's objections, then the party shall complete and sign a resolution addendum to the purchase agreement incorporating all of buyer's objections and seller's agreement to cure those objections. That's the new Form 5143, which is the resolution addendum. And as far as who creates that, normally I would think it would be the seller because the seller has received those requests and their response to that is, yes, I'll do all these things. So normally they would, but it really doesn't matter who creates the resolution addendum as long as one of the parties does create it and everybody signs off on it. Option B, if the seller does not agree to cure all of the buyer's objections in this notice, seller shall complete a response to objections, Form 5142, in which the seller states the objections, if any, that the seller is willing to cure. So option A, this is what happens in the event that the seller wants to do everything the buyer is asking to do. And option B, if the seller does not agree to cure all of the buyer's objections as requested. And then below that is the buyer's withdrawal of objections. And this buyer withdrawal of objections is specific to this form. So the buyer can withdraw this specific notice of objection by using the bottom of this form, or the buyer can use Form 5144, which can be used for withdrawing all objections or multiple objections. So either one will work. Now let's talk about the response to the notice of objection. So for purposes of talking about this form right now, we're going to assume that the buyer has made objections and the seller has not agreed to cure everything just the way the buyer wants it, because if that were the case, then the seller would be creating a resolution addendum and sending that over for signature. So this response is coming about because the seller isn't willing to do exactly as the buyer had requested, but they are willing to do something and they're coming back with a response. So you'll first notice that there is a number at the top because there may be scenarios where there are multiple responses, both from the seller and from the buyer. We'll talk about that in a minute. And then there's a big box below that. And the first bullet in the box says exactly what it said in the last, in the objection that we talked about. This is not an agreement. This form is for use in negotiating the buyer's objections. It does not create an agreement between the parties as to how to resolve the buyer's objections, and it cannot be used for that purpose. We'll see at the bottom of this form that only one party signs this form as well. So there's no agreement that's coming out of this particular form. If the parties come to an agreement regarding how to resolve buyer's objections, the parties shall execute a resolution addendum to the purchase agreement. And then the next bullet tells the party who's receiving this response how they can react to it, how they respond to this response. So we say if seller or buyer as applicable agrees to the response in this notice, that party shall complete and sign a resolution addendum, MR Form 5142, incorporating the applicable buyer's objections and seller's agreement to cure and submit it to the other party for signature. Now, why do we say if buyer or seller as applicable? Because this form initially will be used by the seller when the buyer makes the objections and the seller doesn't want to give the buyer everything they've asked for and they want to come back with a response. Initially, it'll be initiated by the seller. However, if the buyer receives the response from the seller and the buyer doesn't like everything that the seller has proposed and they want to go back with another proposal, then they will use this response form as well. Not the exact same one that the seller sent over. The buyer will go get their own response form and they will send that response form over to the seller. So the first one that comes over from the seller is going to be number one. If the buyer doesn't like those, the buyer is going to get their own response form and complete it. And at the top, it's going to say number two, because it's the response going back over. And then if the seller gets that and doesn't like it, and they want to create a different response, then they will create a brand new response, and that'll be number three. And this will be the process. So we say seller or buyer because both could use this response form. The second bullet under the under there says if the seller or buyer, as applicable, do not agree to the response in this notice, that the party may complete a response to objections in which the party states their proposed response. Notwithstanding the foregoing, if in seller's response to buyer's initial objection, the seller does not agree to cure all of buyer's objections in a manner requested by the buyer, then the buyer may elect to terminate the purchase agreement and receive a refund of earnest money delivered. Now, this isn't new language, and this isn't require an agreement. Nobody's having to sign off this that they agree to this because they already have in the purchase agreement. And sellers, listing brokers need to be aware that's the way the purchase agreement works. So when the buyer makes their objections, if the seller doesn't give the buyer everything that the buyer asked for exactly as they asked for it, then it does put the ball in the buyer's court to terminate the agreement at that point. What's also important for the buyers to understand is that if they make objections, so they're standing at a crossroads and deciding whether to terminate the deal by the objection deadline or whether to make objections, if they elect to make objections, they have to allow the seller an opportunity to respond to those objections. So they can't make objections and then terminate the contract. They have to wait to see what the seller has to say. And after the seller responds, if they haven't given them everything they wanted in their initial objections, then at that point, the buyer can terminate the contract. And the last bullet there talks about consulting with the lender. And that's the same language we saw in the objection notice, which says that the resolution addendum, which is ultimately where this is going, if the parties come to resolution, or other items agreed to by the parties after the purchase agreement is fully executed, may alter the terms of the purchase agreement and require disclosure by buyer to the buyer's lender, and buyers encouraged to consult with the buyer's lender prior to entering into that final resolution addendum, because the resolution addendum may have a detrimental impact on the buyer's ability to get the loan, may cause delays in the lender's processing and funding of the loan by closing, and may require, and as a result of that, the lender may require further inspections or repairs as a result of that resolution addendum. So we're giving them that same notice again. And then there's some space at the bottom where the seller or the buyer, whoever's doing the responding, can start noting their response to the objections or the response to a response. There's lots of white space at the top of page 2 of the response to notice of objections. But in the event that the parties need additional space, then again, you can check this box and it says additional space is required in Exhibit A. MR Form 2200 is attached. Grab Exhibit A. It's 2 blank pages. You could write lots of response language on it and attach it here to Exhibit A. And I will note that underneath that, it is the buyer or seller who is submitting the response who is signing here. So again, not both parties, just the one party who is submitting the response. So again, this is not an agreement because both parties never sign this. The or is very important here. It's only signed by the party who is submitting the response, not both parties. When only one party signs a document, it's not an amendment to the contract because both parties, all parties, have to sign off on an agreement to change the contract. So again, with only the buyer or the seller submitting this response, it never becomes an agreement. It doesn't have to go to the lender. Unless, of course, the lender specifically requests it, and that's a different story. But as far as automatically being submitted, it does not have to be automatically submitted because it's not modifying the contract in any way, shape, or form. Which brings us to the star of the show, the final document in this process, the resolution addendum. At the top of the resolution addendum, page 1, you'll see a place for a number because once again, you could have various resolution addendum, multiple resolution addendums, so you want to number those. Then in the box, you see the language that says consult with a lender. It says that once this addendum is fully executed by buyer and seller, it becomes an addendum to the purchase agreement and it must be provided to the buyer's lender. And buyers encouraged to consult with their lender prior to entering into this agreement or this addendum, which is an agreement, as this addendum may have a detrimental impact on the buyer's ability to get the loan. It may cause delays in the lender's processing and funding of the loan by closing, and it may result in the lender requiring further inspections and or repairs. So again, buyer, consult with your lender before entering into this agreement. And mainly we're talking about paragraph 1 when we're talking about those type things, because obviously price modifications aren't likely to have an impact on the loan if they're reducing pricing. And seller credits will only be allowed as far as the lender will allow them, and then the rest will be a price reduction. So it's really the repairs and replacement, which is paragraph 1A, that could have a real impact on the loan. So again, discussing this with the buyer's lender beforehand is important. The buyer must do that. So paragraph 1 is the seller agrees to cure the buyer's objections as follows. It says check all that applies, because there could be it could be more than one, multiple way that the seller is willing to cure buyer's objections, do a price modification, and, repair a couple of things. So they're going to have to check everything that would apply. On paragraph 1A is the repair replace, and it says seller agrees to do all repair replacements listed below no later than the repair completion deadline set forth in the purchase agreement. So we didn't have a definition for repair completion deadline until now, which is why I highlighted it, but you'll see it in the purchase agreement as well. And it's the date by which those repairs have to be completed. It's a new date that's in the purchase agreement. So I wanted to point that out. And then also the yellow language is new, and it's important because the seller now has additional requirements, not just do the repairs, but first of all repairs shall be completed by an appropriately licensed professional. So whatever licensure is required for whatever that contractor is doing, they have to be properly licensed. And copies of repair invoices shall be provided to buyer on or before the pre-closing walkthrough, and shall include vendor contact information and license number. And we're not talking about a business license number. We're talking about the license number that the entity that licenses that vendor has given them. So whether it be plumbers, electricians, contractors, they'll have a license number issued by the regulatory body. And then this green language is very important because it is different than the way we handle our price modification and seller concession form. And when we get to seller concessions, you'll see that we have mirrored that language after the language we have here in this paragraph 1A. I will also say that we'll be amending the seller concession price modification form so that all these forms align, so that language in that price modification form is the same as what we see here. But under 1A, where we're dealing with repairs, that green says, if seller has agreed to repair or replace items in a prior addendum to the purchase agreement, then unless otherwise noted below, items to be repaired or replaced in that prior addendum shall be in addition to the items that the seller has agreed to repair or replace in this addendum. So again, if you have a prior resolution addendum where the seller says, I'll fix this or I'll replace that, that's going to be in addition to what the seller has agreed to do in this addendum, unless the box is checked. And the box below says, check this box only if the items the seller has agreed to repair or replace below will include all items the seller has agreed to repair or replace. And if this box is checked, this addendum supersedes all prior addendum as to items the seller is required to repair or replace. Okay? So the default is that anything that the seller has already agreed to repair or replace, they're going to have to do those things in addition to whatever they agreed to do here. But if the box is checked, then whatever the seller has agreed to do here incorporates everything that the seller is required to do as far as repairing or replacing things on the property. On page 2 of the resolution addendum, there's a little bit of space at the top of the page, but once again, you see that box. If checked, additional space is required and Exhibit A is attached. So just if the seller is doing a bunch of repairs and replacements and there's not enough room to list them all here, then grab Exhibit A, and there's a couple of blank pages for you to use there. And then paragraph 1B is a price modification. If the buyer and seller agree to amend the purchase price as follows, it'll be listed there. And then paragraph C is seller credits. And again, I've highlighted the fact that we are treating these seller credits differently than we do on the price modification seller concession form, which will be amended or is being amended simultaneously with this so that everything lines up and it's the same on both documents. But if the seller has agreed to provide a seller credit to buyer in a prior addendum to the purchase agreement, then unless otherwise noted below, that seller credit shall be in addition to the seller credit listed in this addendum. So again, very important that the default is that it's going to be in addition. So you're going to add up any prior resolution addenda, any other addenda that might have provided for a seller credit. All those are going to have to be added up unless the box is checked. And if the box is checked, then it means that the seller credit listed above will include all seller credits being given by the seller. And if it's checked, this addendum supersedes all prior addenda as to seller credits. Okay, so very important that the default is that it's not going to be all-inclusive, that this is going to be in addition to any other addenda that has been created before this addenda. However, if the box is checked, then this is a total of seller credits. Going to be very important for both sides to understand that that's the way the form works, and to check the box if it's applicable. And if you just want to add them up, that's fine. That's the default. If you don't want to just add them up and you want this number to be all inclusive, the box has to be checked. And then you'll note at the bottom that the buyer and seller sign this, right? Again, it's an agreement. It's an amendment / addendum to the purchase agreement, and both parties will sign it, and it will have to go to the lender if the buyer is getting a loan. Okay, let's briefly recap this process. So the buyer makes their objections. That's the first thing that always happens. And then from there may be a resolution addendum right out the gate. They may send them over. The seller may agree to everything. The seller would create a resolution addendum setting forth the buyer's objections and the seller's willingness to cure everything just as the buyer had asked for it. And then they send that back over to the buyer for signature, and that's your resolution. Alternatively, when the seller receives the buyer's objections, the seller could respond. And if they responded, then it would go back to the buyer, who would make a decision as to whether or not that was an acceptable response. If it was, the buyer would draft a resolution addendum. If it wasn't, then the buyer would then create their own response and send it back to the seller. And those responses, again, would go back and forth until they had come to an agreement, at which time the party who last received the response that they agreed to would create a resolution addendum and send it over to the other side. So that's the process in a nutshell. The next new form in this process is the Notice of Withdrawal of Buyer's Objections, Form 5144. And as I said earlier, the buyer can withdraw objections, a specific notice of objection, by sending over the original notice of objection with the bottom part of that objection filled out, which withdraws that specific notice of objection. But in the event that the buyer wishes to withdraw all of their objections or a number of their objections, then they would fill out this form. The first part of the form allows them to identify the objections that they're withdrawing. And it's important, very important, that it be very clear about what notice of objections that they are withdrawing. So we want it to be identified both by number, because certain number of, the numbers at the top of the page indicate what number of objection it is that the buyer has made, and then also the date that that objection was made. So number and date. And then in the box below that, the first bullet talks about our new resolution process, in which if the buyer and seller do not reach resolution by the resolution deadline, then the buyer has 2 days following the deadline to withdraw all of their unresolved objections, and that keeps the contract from terminating. So they have that 2-day period. In the event that they do not withdraw their objections on or before those 2 days after the resolution deadline, then the contract will terminate and the earnest money will go back to the buyer. Then we tell the buyer that in withdrawing the above referenced notices of objections, buyer understands that seller is not obligated to repair or otherwise remedy those buyer objections for which resolution has not been reached, and seller is still obligated to repair or otherwise remedy objections for which resolution has been reached. Such repairs or remedies to be conducted as agreed upon between the parties in the resolution addendum. And then we define resolution. It's very important. If the parties don't enter into a resolution addendum, there's no resolution. So the buyer will make their objections, the seller will create responses, maybe the buyer creates their own response, but ultimately, no matter what happens in that process, what has to happen in order to reach resolution is there has to be a resolution addendum created. There's got to be an agreement signed by the two parties saying this is how we want to resolve the issues. And remember that neither the objection or the response are signed by both parties. So those aren't agreements, and they should never be used like agreements. And the minute they are used as an agreement, then they're going to have to go to the lender. So the intent is for the parties to be able to negotiate these things without those documents having to go to the lender or being any kind of amendment to the contract or changing anything that the parties had already previously agreed to. And then when they come to a resolution, then that's memorialized in this resolution addendum. But until that happens, there's no agreement. So it doesn't matter what the brokers say to each other. It doesn't even matter what the buyers and the sellers say to each other. It's what ends up on that resolution addendum that's signed off that creates that resolution. Now we've come to the last form in this new process, and it's a new form. It's a waiver of inspections and observations contingency, Form 5140. And currently in our purchase agreement, we have checkboxes, much like what you see here under paragraph 1, that says that the buyer is waiving all inspections or all inspections unless required by the lender or the following inspections. But the Forms Committee felt like the waiver of inspections was a big deal. That's an important aspect of this purchase agreement. We want the buyers to be doing their inspections. And if they are going to waive their inspections, then they need to be doing it very thoughtfully. And checking a box in the purchase agreement we didn't feel was thoughtful enough. And so we are now taking those boxes out of the purchase agreement and pushing them off the purchase agreement to this form if they wish to waive their inspections. And in the box at the beginning of the top of the page, says that the buyer is advised to exercise all their rights under in accordance with the purchase agreement to investigate the property. And we reference the home inspector information sheet or the home inspections information sheet because it has a lot of great information about what the buyer would be getting if they were to conduct a home inspection, things that they would learn about the home, perhaps if they have a home inspection. Paragraph 1, again, is much like what you see right now currently in our purchase agreement. Paragraph 2 is all new language that we added for this specific form, of course. And it's an acknowledgement and it's a disclaimer. So the acknowledgement says that buyer will not have the opportunity to conduct any of the waived inspections in paragraph 1 and will not have the right to object to or terminate the purchase agreement based on buyer's observations of the property or issues or defects that may have been revealed by the buyer's inspections. Notwithstanding the foregoing, the buyer retains the right to make objections in accordance with the purchase agreement to seller provided documents or disclosures. So there may be something that could have come up or would likely have come up during an inspection and the buyers waived those inspections, so they've lost the right to terminate the deal or object to those things because they didn't do their inspections. However, if there is an item, a defect, or an issue that has been brought to the buyer's attention by a disclosure that the seller has given them, seller disclosure or other document, the buyer is not waiving their right to object and terminate based on that particular document or that particular seller disclosure, only to the inspection. So that's what that last sentence means, is that the buyer retains the right to make objections in accordance with the purchase agreement to seller provided documents or disclosures. The A2 says if the buyer fails to close on the property due to buyer's own observations or some defect issue that would have been revealed by buyer's inspections, which was not otherwise revealed by a document or disclosure provided by the seller, then the buyer may be in default to the purchase agreement. And then the disclaimer in 2B says that buyer's decision to waive the inspection and observation contingency as to the inspections indicated above is not based on any representations made by the seller, the listing broker, or the buyer's broker. For good and valuable consideration, the sufficiency of which is hereby acknowledged. That's consideration. You have to have consideration for an agreement, right? Buyer does forever hold harmless the seller, brokers, and brokerages with respect to any damages the buyer may suffer as a result of this waiver. So the buyer is, again, we're attempting to say, hey, buyer, this is on you if you decide to do this. You're not going to hold the seller responsible for things that the seller, that may have been disclosed or revealed by inspections. Again, that doesn't alleviate the seller's responsibility or to disclose what they know about the property. But if the seller is unaware of something and the buyer could have learned about that something if they had done their inspections and they didn't do their inspections, they waived those, they're not going to be holding the seller responsible for that or the listing broker or the buyer's broker. And so we feel like, again, really emphasizing the importance of inspections and really reiterating or explaining and trying to be very clear with the buyer about what they're giving up in the event that they should decide not to do inspections is a much more prudent approach to this waiver of inspections than what we currently have, which again is just check boxes in the purchase agreement. If you have questions about this process or these forms, please contact me on the legal hotline. You can call me at 1-877-699-7266 or 1-505-821-1583, or you can email me at legalhotline@nmrealtor.com. Also, please don't forget to review the materials available explaining the changes to the purchase agreement. We've gone over some of those today, but there are additional materials available, so review those. And if you have questions about those, call or email me as well. Thanks very much and have a great day.